In view of the discussions made herein above, this court is of the considered opinion that the petitioners are not entitled for relief sought for in terms of the provisions of section 30 within bracket 3, subsection 3 of section 30, section 80, and section 93 of Right to Fair Compensation Act 2030. Therefore, this court is not inclined to grant same under aforesaid provisions. However, in view of the principle of law laid down by the Honorable Supreme Court, this court direct the Deputy Commissioner collector to examine and consider the question of payment of rent damages to the petitioners from the period when their respective lands were taken possession, that is 1986, till the date of issuance of the notification in the year 2009, and the interest from the first notification in 2009 till the award on the additional compensation, only for the reason that the petitioners have been already provided interest for 1 year. Such exercise shall be completed within a period of 3 months from the date of receipt of certified copy. Writ petition is still disposed of.
May it please, Your Lordship.
Yes.
Your Lordship, I would like to mention item number 28 and 29, connected appeal, Your Lordship.
Yes.
Your Lordship, this matter is conducted by my learned sister T. Jini. She's out of station and brief is also with her. So, this matter may not be taken up for this week, maybe fixed on next week.
Change your style.
Sorry, Your Lordship.
Making a mention on the ground of brief being handled by the your colleague.
Yes, Your Lordship.
Who is absent. I mean, he's maybe busy or somewhere else. You change the distance. That should not be a ground. Well, adjourn it. No issue, but then that cannot be a ground. Because is it a case that once the brief is entrusted to your friend or any public prosecutor, cannot be taken up by some other additional PP?
You're no doubt, Your Lordship, that can be taken up, but Your Lordship, brief is not in the office. That is the issue.
Why? If she is away, it's not your personal property.
Absolutely, Your Lordship. But so far as Your Lordship,
your status as a PP is much more than you have more responsibility than your colleague.
absolutely,
lawyer.
Your Lordship.
Because why I have to make this? Because I am observing it since last 1 week.
Yes, Your Lordship, and unfortunately this week when she is not available or her matter has
So
been...
it's okay, she may not be available, but then is it that case that you, once it is entrusted, no one can touch the brief?
But Your Lordship, problem is that the brief is taken, Your Lordship, for appeal matter. For other matter, Your Lordship, there is no issue that we can pursue the matter and we can prepare it accordingly. But appeal, we have to go through all the evidence.
We get the cause list 1 day before.
Yes, Your Lordship.
We go through the records and or the files in the evening. You got this cause list yesterday, not this morning. It's for not only to you, all the PP and the additional PP. Anyway, Mr. T at the London additional PP submits that item 28 and 29, huh? The learned additional PP, Mr. Ms. T. Jini, who is handling this matter.
Yes.
What is her ground?
Sorry, Your Lordship.
Where she is now?
She is out of station, Your Lordship.
Is out of station. List of. Therefore, he prays that matter may be listed after
A week.
After a week. On the ground of his colleague being out of station. List of. Normally, such a ground cannot be accepted for adjournment of the matter. as the as if the matters are listed and the office of the public prosecutor should arrange entrust the briefs to other learned additional PP if the additional PP engaged entrusted with the brief is indisposed. However, considering that the consider for as a no, however, considering that the brief in this matter in these matters are with the learned additional PP MSTGD, who is stated to be out of station, and having no alternative, the matters be let these matters be listed after a week. It is expected that the learned counsel would not repeat such a prayer for adjournment on such ground in near future. List after 1 week. See, just because she's out of or he's out of station, it cannot be ground.
Oblige.
Your Lordship, item number 30 also.
Same ground
Same ground.
with the PP.
Yes.
Huh?
Yes, Your Lordship.
With TGD.
Yes.
Then in that case, I'll add some more words. All right,
Oblige, Your Lordship.
30 also.
Lordship. I beg to
Yes.
mention item number 27.
Item number
27.
20?
27.
Why?
Lordship met. Leading counsel L permits attending his father medical. Due to medical ground, Mr. L permits not able to.
Medical ground we can understand. Mr. S. Yera,
Yes.
learned counsel, appearing for the petitioner, submits that the leading counsel, Mr. L. Perme, is under
Attending his father.
under medical treatment
Attending his father.
or under L. Perme is attending his father for medical treatment for which he prays for listing the matter after
3 weeks.
3 weeks. Mr. T. That the learned additional PP is present. List up with 3 weeks. This medical ground we can understand.
Yes, Your Lordship. Yeah, last night also he's informed me his father is suffering from
Yes.
some serious illness.
That may be a genuine. But brief.
Oblige.
Yes.
Yeah, Lordship. Lordship, I beg to mention item number 26.
26.
Yes,
Again,
yes.
what is this?
My leading counsel is out of station.
I'm having
We'll
the-
hear him. We'll dismiss the criminal this
Yeah.
revision petition. You take the court copy now. Read it. This is not done.
I'm having the same.
At least
since
the
yesterday.
hearing,
Yeah.
or if it is on medical ground, we can understand. It is not done.
Yesterday also the same thing. So last night itself I inquired and I'm told Mr. Tama is out of station. So yesterday also the same prayer was made. All available.
Board,
All available.
foreman having a eye problem had to look into the records and he files in the evening.
Absolutely.
And then
Luckily for
next,
me, I inquired myself yesterday.
next morning we came to know that.
Yesterday, so even after I came here only I came to know.
We'll just because these are 21 and 22 matters, so it's okay, but then otherwise,
Yes.
all matters we
Yes.
cannot. And I
Because-
request all of you, don't make a mention that the lawyer is out of station. You arrange whatever you want to do it. Unless
Because
it is-
item 30, the person is in jail, custody. So what
Yes.
to do?
help it out.
And Mr. Tama is not here.
MS
El Asha,
El Asa,
yes.
Learned Counsel appearing on behalf of Mr. K. Tama, Learned Counsel to the respondent. Submits that Mr. K. Tama, a leading counsel in this, leading counsel appearing for respondent number, respondent is out of station, for which the prayer has been made for adjournment of the matter after 4 weeks,
After
3
4
weeks,
weeks,
3 weeks,
4 weeks.
4 weeks, 3 weeks. Mr. Prayers alone. Mr. Deepang, Learned Counsel for the petitioner is present. List after 3 weeks. 3 weeks. That number? Yes,
May I please look?
yes.
This is the application under section 482 of CRPC
Hmm.
for quashing of the FIR and the entire proceeding arise out of Jintu PS case number 47/21 under section 380.
What is the stage? Stage of proceedings?
Lordship, so far, only one of the prosecution evidence has been recorded.
Evidence,
Only one of the prosecution witnesses statement has been recorded.
examined and recorded. Okay.
Rest is that.
Heard Mr. Tita, Learned Counsel for the petitioner. Petitioners, how many, two petitioners,
Three petitioners.
380
Yes, Lord.
Yes, Lordship.
This
step closer.
Theft in a dwelling.
dwelling house, 380, yeah.
It's a motorbike.
Next para, this is an application under section 482 of CRPC, 1973. Praying for quashment of, what is the GR case number? Criminal proceedings of GR case number? Where is the GR case number?
Lordship,
You have not mentioned it.
Yes, Lordship, I have mentioned the FIR.
You are not for FIR. Where it is?
Lordship, I have not mentioned the GR.
Where it is? How do we find it?
I have not mentioned, Lordship.
If you have not mentioned, how do we find it? From where? Should we call for the number from the court?
Lordship,
Should I call from the, call the number from the court, or should I find out myself?
Lordship, I will make it correction. I have not mentioned the GR. I have only written the FIR.
Correct it, we'll take it up tomorrow.
Permission maybe.
List the method. Don't write it. List the method. List this method tomorrow.
Lordship, we take permission to correct.
What correction?
To add the GR number.
You don't know the GN number. You said that one PW has been examined and recorded. What is this?
2 days, I'll get the CP.
Withdraw and file afresh.
Okay.
Mr. Tita, Learned Counsel for the petitioner submits that he may be allowed to withdraw this present petition with the liberty to file fresh Mr. Praise the Lord. Petition stands disposed of. Close of withdraw. We deliver the express.
Lost. Take the.
Right.
Number 20. This is second bill, anticipation bill application.
This is
No,
successive bail, your lordship. Successive bail. Successive anticipatory
Okay.
bail.
What is the next?
My lord,
What is the new ground?
my ground is that, there is two different cases, my lord. One is pending before the session court, my lord, where, the applicant, got the absolute bail, my lord. I have annexed the, order copy, my lord. Register, next E, my lord. Page number 23.
We'll call for the case diary. You have committed the same offense.
My lord, that is not true, my lord. That is different matter, my lord.
Different case, but then while on bail, you have committed the same kind of offense. You have involved in same, at least you have been involved in the same offense. No entry will call for this case diary. All right.
Still that, it may be granted.
It cannot be a new, I think, a new ground.
Yes, that has already been discussed
It's
by
a
the.
view of the court, wrongly or rightly. The ground of rejection is that you are the accused of some other case, well on bail, you have committed the same kind of offense.
But in the session court, bail was granted.
It's okay, that's what I'm saying, well on bail. While on bail, you have committed the same offense, using the arms and all.
But,
We'll see. Or Mr.
PK board,
Huh?
Pramod Kumar board.
PK Gore, learn counsel for the
Till
applicant,
date,
applicant
implemented-
accused. We cannot. It is not a new ground. This cannot be a new ground. You are trying to argue that this court, while rejecting your earlier bail application, has not properly, analyzed. That cannot be a new ground. Is not it?
Yes, your lordship.
That it was in the other case. Right?
My lord, when the.
This is an application under section, application for, under section 430 of CRPC, 1970. For grant of privilege of pre-arrest bail to the applicant accused in connection with Balajan PS case number 02 of 2024 under section 341, 397, 324, 27, 506 of IPC. No, I'm saying,
Here, no, I'm saying,
Here,
the
no.
earlier one, your lordship. And that aspect has been considered by this court, your lordship. Because it was reflected in the case diary that prior to the, after granting the interim bail in that bail application, he has committed the offense.
but there's no,
But, the arms belong to the other person, my lord.
arms
Other group of, person, my lord. Not belong to the, applicant, my lord.
Your lordship may kindly see the earlier order passed by this honorable court, your
yes,
lordship.
I've seen it.
Yes, your lord. On the ground that she is a habitual offender, your lordship.
But
The
my
same
lord,
kind
it
of
is not
offense.
true. The time of the commission of.
No, just because somebody is involved in other case,
Yes, my lord.
and if he is eligible in the next case, cannot be habitual offender.
Your lordship, it's not required that in the same case that person has to
This
commit
is-
offense.
those were the issues regarding land dispute where hundreds of people. were
Even your
involved.
lordship, this case, the present case, if your lordship peruse the case, that is somehow connected. It's a there is a
In
difference.
that case, we'll call for the case then. Call for the skin copy of the case then.
Yes.
My lord, my prayer is, until that.
Your prayer is rejected. We'll see. Will not reject it. Mr. T at the London additional PP appears for this state. Should I reject it or should I keep it like that?
No, my lord. CD may be called, my lord.
But there's no
No
New
fresh
ground.
ground.
list after 2 weeks.
No.
2 weeks or after a week?
After.
After a week.
Oblige, your lordship.
Your Lordship.
Yes,
Lordship, I'm praying for anticipatory bail.
yes.
The facts in brief in this case, Your Lordship, I am a married man having 2 kids.
Why
And
you have involved all this thing, indulge on all this, if you are a married man?
it was, this fact was known to both of us, Your Lordship. Even she was well aware of the fact that I'm a married man. And she herself is a married woman having 3 kids.
Doesn't matter.
And then because she is a married woman in her 30s, and she is mature enough to understand the consequences of the relationship. So you're looking in what happened in brief is that we met in each other.
Let us see the FIR.
Yes, Lordship. That is in page 15, Your Lordship. That marriage, Your Lordship.
It's okay. Call for the case there.
Your Lordship, I pray that I may be interim bail.
Mr.
K. Taja.
K. Taja, learned counsel. Heard Mr. K. Taja, learned counsel. For applicant accused, next paragraph. This is in bail application and this is an application under section 438, huh? For bring for grant of privilege the pre-arrest bail to get. Applicant accused in connection with Itana Women PS case number 12 of 2024 under section 498A IPC. 498A. Let us see.
498 cruelty, Your Lordship. And moreover, and in this section, the police cannot arrest mechanically in light of the judgment rendered in Ernest Kumar case, Your Lordship.
That's why a notice has been given.
Yes, Your Lordship.
Not attracted at all.
Sorry, Your Lordship.
Cannot be attracted.
Yes, Your Lordship.
498.
Otherwise, the other section is attracted. So far as the allegation is concerned, it's a false promise, Your Lordship.
No.
The allegation.
498A.
Yes, but register under 498. The cruelty, Your Lordship. Husband or relative of a woman subjecting her to
Yeah,
cruelty.
husband and wife.
Yes, Your Lordship.
How can this be attracted?
They have wrongly registered, in fact, Your Lordship. Otherwise, he said false promise of marriage 376 would have been
It should be what? Section?
376 read with section 90. If Your Lordship may see the section 90, 376 is the rape, but section 90, consent known to be given under fear or misconception.
Where is the false promise?
Your Lordship, the consent has been taken by not disclosing that he is already a married person, or he's already divorced with his first wife. You know. On that fact, he has taken the consent of the victim, you know, as far the allegation is concerned.
What happened to this section 499(7)? No,
498.
497. It was struck down by the Supreme Court.
Sorry, Your Lordship.
Struck down by the Supreme Court.
497.
Thereafter, what happened? Parliament has done anything?
Adultery, yes, Your Lordship.
497.
Yes, Your Lordship. Adultery.
That
It has been struck down.
This has been struck down. by-
Yes, Your Lordship. This can be a ground for divorce, but it's not a penal provision anymore. But here, Your Lordship, as per the allegation, it's a consent has been taken
What is the last one?
on misconception of fact.
438. Will be alleged to the accused, applicant accused in connection with Ethano WPS case number so and so. 498A capital A IPC. Come on. Call for the scanned copy of case diary. Huh? Scanned copy of the case diary. Next para. In the interim. No, not interim. Considering the facts and circumstances. And the offense and parenthesis, the offense under section 490A IPC may not be attracted in the present case, comma. In the interim, the applicant on the event of arrest, the applicant accused shall be namely so and so released on bail. On furnishing a bail bond of rupees,
10,000.
huh?
10,000 years.
15,000. 15,000.
10.
15,000. And surety of like amount to the satisfaction of the arresting authority on the following grounds. You appear? The accused applicant shall appear before the investigating authority within 5 days from today. Then some other that goes. Other conditions you put it, huh?
Matter may be released again on 21st.
List this matter on 21/05/2020.
Obliged, Your
Thank
Lordship.
you, Lordship. Deeply obliged.
What is this?
My lord, this writ has been filed, my lord, praying for direction to dispose of the representation which
No,
is pending.
You cannot
before the-
just like that.
Now, my lord, the facts behind the representation is, my lord, I have the plot of the land and I have disputed with the other party in the years 2021, and accordingly, my lord, this title,
You have not pursued your writ petition, you have withdrawn it, or has it been dismissed?
no, my lord, that was dismissed on
It's
the,
dismissed.
yes, my
On
lord,
the ground that the land falls under the wildlife sanctuary.
wildlife
Then-
sanctuary. Now,
then-
now, my lord,
Now you are saying that some illegal occupants have not been,
eg-
no
eg-
action has been.
Exactly, my lord. What I'm trying to, my lord, find out that, what I'm trying to submit, my lord, there was a, my lord, title suit over the other
Sir.
person. And in the meantime, my
Sir,
lord,
there is no concept of negative equality. If they are not doing it, it's okay.
my lord, there is no such, my lord, the equality. Why the department, my lord, other person are allowing still today. Therefore, my representation is that why the department has driven out me from
Where
that
is the law
area.
that your representation should be considered?
Of course, my lord,
So as any law.
so far the, my lord, circumstances in the
You
present
must-
case
you
is,
must-
my lord,
You must establish some semblance of right.
my lord.
Then we may consider directing them to consider your case. You are admitting everything, saying that it's the land fall under the wildlife sanctuary.
My lord, why I am saying so, it is not me, but this is the department who established that the land is
Then
all
you have not
within the
pursued-
land
Your
sanctuary.
writ petition has been dismissed. Matter ends there.
That writ petition was, my lord, only pertaining to the eviction matter. Now, my question is that, yes, I have been evicted from that area. And despite that, why the other people are still, my lord,
That is
continuing
called-
that
that is
area?
why claiming negative equality.
Why, my lord, I should
Equality
be,
on negativity.
I have been singled out, my lord. And so I question to the department that you have been evicted me from that area, but now
Are you
till
withdraw-
today,
are you withdrawing or I'm
you
dismissing it?
are allowing the other person to
Sorry, sir.
continue that. My lord, if my lord not inclined, my lord, then with liberty, my lord, I'll take it, because
What
if,
liberty? No,
if necessary, my lord,
not necessary. You may pursue some other appropriate forum, not at least by writ petition, no.
then in such situation, my lord,
Not only this court, you being the officer and you being the considerable experience in the profession, you should not encourage such type of litigation.
but so far, my lord, what I found, my
Withdraw or
lord,
dismissal on merit.
my lord, am I allowed to withdraw, my lord?
I'm not forcing you, huh? If you want me to dispose, I'll dispose of it. I'll dismiss it. There's no case.
No.
Right?
My lord, let's dismiss, my lord.
Huh?
My lord,
I'll dismiss it.
my lord.
Okay.
Because, my lord, there will be, my lord, lingering process when that's my lord, no?
Mr. What is your state?
Yes, Lordship, since this is already decided, matter has been, this is hit by section 11 of res judicata, Lordship,
Yes.
also. And
Mr.
the other person he is pointing, he have not made them party.
C. Modi, learned counsel for the petitioner, also had Ms.
Yeah, for all the official
G. at the
responses.
learned additional senior government advocate for all the respondents.
Yes, Lordship.
By filing this writ petition, the petitioner has sought for a direction to the respondent number 2 to dispose of the representation of the petitioner dated 24/2/2024. On the ground of equity, justice, and good conscience. Lister. Before that, Before that, number 1, you just write, considering the nature of the prayer involved in this writ petition, made in this writ petition, this petition is taken up for disposal at the motion stage. Next one. The case projected by the petition is to the effect that the petitioner had occupied a plot of land in the year 2005. Please stop. In the year 2021, a dispute has arisen over the title with the adjacent landowners. Mr. In the meantime, the Forest Department has issued an eviction notice to the petitioner, which was put to challenge in writ petition being WPC number 107 of 2021. The said writ petition was dismissed by this court. Where is that dismissal order?
In the page number 15. It is start from
21/04/2022.
17.
There are 4 Lordship, 4 and 5.
Is the land which the petitioner has occupied falls within the Itanagar or Homa.
Itanagar lobby, Lordship.
Itanagar Wildlife Sanctuary.
Yes, lobby area. Yes.
It's another wildlife sanctuary.
Itanagar Wildlife Sanctuary. Mr. Thereafter, the petitioner, according to him, being a law-abiding citizen, did not pursue the matter further. Mr. The writ petitioner contended that while the matter was rested on the respondent authority has allowed some illegal occupants in the said wildlife, eternal wildlife sanctuary. Whereas the petitioner has been evicted from the said land. Mr. C. Modi, learned counsel for the petitioner, submits that on knowing that some illegal occupants have been allowed to continue to occupy their land, whose land also falls under eternal welfare sanctuary. Well, evicted the petitioner, he filed a representation on 24/02/2024. However, he has not, the authority has not taken any action on either on the representation or for or evicting the illegal occupants. MSG at Learned Additional Senior Government Advocate submits that the dispute regarding the land has been settled in view of the order of this court dated 21/04/2022. Passed in writ petition, within bracket supra, bracket clause, against the petitioner as the land uncontrovertibly falls under the eternal wildlife sanctuary. Mr. Petition not having taken further course of action, he cannot agitate the same by filing this presentation with petition. Next paragraph. Undisputedly, the land falls under the land occupied by the petitioner falls under the eternal wildlife sanctuary. And the eviction has been, the petitioner has already been evicted. Therefore, the claim of the petition has been considered in the earlier round of writ proceedings, being WPC 107 of 2020, wherein this court, by which by order dated 21/04/2022, this court has dismissed the writ petition. Having considered the regarding head to the submission of learned counsel by the petitioner, that some other persons who are illegally occupying the land within the wildlife sanctuary, eternal wildlife sanctuary, has not been evicted. Therefore, the petitioner has the right to, he has a right to, he has also right to occupy the same if the other illegal occupants are not evicted. Next. Having considered the, which this court finds is too tenuous to accept, as in essence, it amounts to claiming negative equality, which is not permissible under the law. It is well settled that the well settled of the law that no one can claim equality, a negative equality as there's no concept of negative equality under the law. The representation, since this court finds that the petitioner doesn't have a semblance of right to approach the authority by claiming the negative equality, the prayer for disposal of the representation cannot also be considered in this by exercising the writ jurisdiction of this court. In view of the above, the writ petition stands dismissed
All right.
with a cost of 50,000.
No way. All right.
Hello.
Yes.
Lordship, this is a joint application under 482 CRPC.
Hmm.
Lordship, I have filed affidavit as per order dated 2/5/2024.
Hmm.
Affidavit has been filed by victim and the informant.
Now it is.
Definitely, I have filed it.
Additional affidavit.
Yes, Lordship.
Yes. What is to be done?
Lordship, since this is a joint application,
We will accept the affidavit.
Lordship.
Then
Lordship, the matter may be, this case may be quashed by invoking.
what is the offense? Serious offense, 307.
Yes, Lordship, there is, that is there, 307 is there. Three 41, 427, 307, 326.
Hmm.
Still, Lordship. Allegation is serious, but however, Lordship, the parties have settled the dispute.
What is the stage of proceedings?
PW. Now PW 5 and 6 is being summoned. PW 1, 2, 3, and 4 has been crossed and deposited at age.
Just because you have settled the matter, can it be quashed?
Lordship, since there is authority, Lordship can invoke the 482.
No, this is not the issue. What is your relations?
Lordship, we
How
have,
you are related to each other?
yes, we have clan brothers.
Hmm.
We are a clan brother.
Then
So by involving the clan members, the settlement has been arrived in 2 occasions that I have annexed in para 50 to 55. Prisoner 50 to 55.
where is the FIR? Where is the FIR?
FR at Lordship, price number
Type copy is 22, Lordship.
Yes,
copy for the page number 22.
24.
22.
It's a bit-
Oh, this is, sorry, Lordship, this is, charge sheet, Lordship. FR page 46, Lordship, type copy. Page 46, type,
46.
Lordship.
Hmm. Yes,
Lordship, in this Lordship, this, the case law Lordship, judgment, the state of Madhya Pradesh versus Lakshmi Narayan Lordship. 29.6.
you give me the Kapil Gupta. Kapil Gupta's.
That's a date I have not bring Lordship today.
Hmm.
That I
Kapil
have
Gupta
not
is-
bring to.
Supreme today is very difficult. It's easy to find out the case law, but then which
And-
paragraph?
Paragraph 12, Lordship. 12 and 14. Lordship.
Lordship, in the paragraph 12, Lordship, this is 29.6 offenses under section 307 IPC would fall in the category of heinous and serious offenses, therefore are to be generally treated as crime against society, not against the individual alone. However, the High Court would not raise its decision merely because there is a mention of section 307 IPC in the FIR or the charge is framed under this provision. It would be open to the High Court to examine as to whether incorporation of section 307 IPC, therefore the sake of it, or the prosecution has collected sufficient evidence, which if proved and would lead to proving the charge under section 307 IPC. For this purpose, it would be open to the High Court to go for by the nature of injury sustained, whether such injury inflicted on the vital delicate parts of the body, nature of weapons, etc. Medical report in such respect of injuries suffered by the victim can generally be the guiding factor. On the basis of the prima facie analysis, the High Court can examine as to whether there is a strong possibility of conviction. The chances of conviction are remote and blink. In the former case, it can refuse to accept the settlement and quash the criminal proceeding, whereas in the latest case, it would be permissible for the High Court to accept the plea, compounding the offense based on complete settlement between the parties. At this stage, the court can also be swayed by the fact that the settlement between parties is going to result in harmony between them, which may improve their future relationship. This is for the Lordship, section 307.
What is the compromise? Settlement. Settlement.
Lordship has 50 to 55.
Where's the respondent, the informant?
Informant is a
There's
first
no settlement between,
settlement, state Tanabado.
huh?
Tanabado,
Where it is?
first down below, page number 55.
There are two settlements,
Yes,
huh?
yes, Lordship.
Yes. Are you objecting?
Lordship, here, Lordship, if they have settled amicably, Lordship, and as per the last
No, but
observation, Lordship,
that, just because they have settled, it will be ground for setting aside
Lordship,
or quashing.
Lordship. Lordship,
There
here
is no
also,
doubt in
Lordship,
that.
Lordship, here, Lordship, also, in this Lakshmi Nayan, Lordship, it is made observation that the High Court has passed the criminal prosecution offences under section 307 and 35 mechanically, even when the investigation was under process. Somehow the accused managed to
Yes,
enter
I have
into
read
the
that, but you
Lordship.
tell us on the basis of these facts.
Lordship, it's up to the Lordship, Lordship, because Lordship, is the, in the stage of, this PW Lordship, and the materials also been collected, Lordship, during the investigation.
Material has not been collected.
No, it's been
even after
collected.
the
No,
trial has begun.
it is collected, Lordship.
Okay, then.
It is pending before the trial court, Lordship. They have come for the settlement, Lordship, under 482.
See, these, the accused and the victim was young, I mean, boys, around
Yes, sir.
25, 26 years.
Lordship,
And it was during the Nyokum festival.
Lordship.
Obviously, it happened.
They said, Lordship, if they have mutually amicably settled their dispute in for the Lordship harmony of their relationship, then it is up to the court, Lordship, for the court decision, it can be settled, Lordship. We just
What
see
do you
whether,
say?
Lordship,
I'm not able to understand.
Lordship,
Are you opposing or are you supporting?
Lordship, as a Lordship, public prosecutors, I am just assisting this court, Lordship,
Yes.
by providing this judgment
Well,
that
assisting, what is your submission?
that Lordship, it can be Lordship, because 307, it can be quasi Lordship.
Okay.
We'll see, Lordship, whether
So it is 307.
Lordship.
Yes. Heard. Mr. R. Ingo, learned counsel for the petitioner. Petitioners. And also heard MS L. Hage, learned additional PP for the state of Arunachal Pradesh. This is an application under section 482 of CRPC, 1973 for quashment of criminal proceedings of GR case number
Yes. Doimuk PS case number 0615.
No, I'm asking the GR case number.
Oh, Sessions case number 37 of
Sessions case number, where it is,
2016.
where it is,
I mentioned in lordship, my
Huh?
cited lordship.
where it is. Sessions case number
Sessions case-
37 of 2016. Huh?
Lordship.
Jointly filed by the petitioners.
37 or 27?
37.
Huh? Yes,
37 of
37 of 2016. And the section 341, 427, 307, 326 of IPC. Corresponding to Doimuk PS case number. What is Doimuk PS case number again?
06
06 of
2015.
2015. 2015,
15.
where it is?
In FIR it's in lordship.
On the ground of settlement amongst the petitioners. Where is the FIR?
Page number 45 and that of
FIR, FIR, FIR,
45.
next para. Petition number 1 is an accused. Petition number 2 is a victim and the petition number 3 is a informant. Mr. An FIR was lodged by the petition number 3. Huh? Who is the father of the petition number 1? Sorry, petition number 2.
Petition number 12.
Petition number 2. Stating that the petition number 1, a resident of Rono village, has physically assaulted his son with local dog on 23rd 02/2015 around 2 p.m. No, 02:00 hours at Rono Road without any reason. It also alleged that his son's car, he alleged that the petition number 1 has blocked the car of the petition, car of his son, and attempted to murder the petition number 2 with the dog. As a result, his son sustained grievous injury, which is admitted at the state Hospital Lahore. A case was registered being Naimuk PS case number 6, huh?
Yes.
6 of 2015. And the section this is also you have said where it is,
341,
huh?
341.
No, where is the case number of the Naimuk PS case number?
Lordship, it is written in the FIR, the body of FIR itself. Why the?
06 of in your body of the petition, US 37
Lordship, it is reflected in
and
this
section
type of
341.
witness, this
Not 27.
statement of witnesses also, Lordship.
Yes, 37
Public
is special case number.
307 of 210, public 326 IPC. Mr. On completion of the investigation, a charge sheet was filed before the charge sheet was made, charge sheet had been laid. The stage of trial is the prosecution evidence. Prosecution evidence.
Lordship.
List of- The stage of trial is evidence of the prosecution witnesses. List of- During the pendency of the trial, the parties have settled their matters, settled the matters. Firstly, on first, this is page 50.
50 is first
The
one.
first, during the, this is before filing charge sheet.
No, Lordship, this is the after trial commencement of trial.
During the pendency of the trial, the respondent, petition number 1 and 2, in bracket, victim and the accused have entered into a settlement by dated 26/1/2018. Just thereafter, but another settlement dated 31/08/2023. By a compromise of the settlement in the line of customary practice, the petitioners have finally settled the matters amicably and settled the matters amongst them. Mr. Next para, are learned counsel for the petitioners, submits that. Due to misinformation, the petitioner number 3 has lost the FIR. And the however, after the investigation No doubt. But since the parties are clan brothers, having no enmity, and the petitioner being the petitioner number one, and petitioner number two being aged about 25 years, 25 and 26 years respectively. And also, as well as the incident happened during the Nyakum festival. The parties have realized and settled the matters amicably to have a cordial mutual relationship among the family members. He further submits that there is submits that though the charge sheet has been filed under section 307 of IPC, there is no incursions against the accused, petition number, that is I petition number 1. He submits that since the parties have settled the matter, there is no chance of conviction against the accused, which if allowed to continue the criminal proceedings would be a abuse of process of the court. Therefore, it is for sitting as a bit and for questioning of but for questioning of the criminal proceedings being out of Citizens Case number 37 of 2018.
2015 was.
2015 or 18?
Settlement was made in 2018 for settlement. And the case is
No, no, Sessions Case number
Sessions case number 2016 was.
16. MS L. Hage, Learned Edison PP. Is there anything in the yes, what is your submission?
Lordship, my submission that Lordship, the 307 Lordship, the 482 can be invoked Lordship if the parties has come under settlement amicably. for
Have
the
you gone through the, yes, the court?
Lordship. It is in the stage of Lordship, evidence Lordship.
How many PWs? 5, 4 so far.
Four,
4
sir.
PWs. It establishes evidence against you. Have you check up this?
Yes, Lordship,
Evidence.
however, the informant, he has declined to identify the alleged accused person. That is,
Huh?
no, the informant, he himself has declined to identify the accused person before the trial.
But the statement,
Yes, Lordship, on cross, Lordship.
hmm?
During the cross,
Show us with the cross.
and even the weapon that alleged to be used in a offense has not been exhibited before the trial. The police said, did not recover.
This is by the informant. What about the victim? Have you seen the victim statement of the victim?
Yes, Lordship.
Hmm?
And even victim has
Yeah,
stated
detail.
that the weapon that alleged to be used during the commission of offense has not been produced before the honorable trial court.
Submits that, huh, madam? This court may exercise power of inherent power, I mean, 482 of CRPC. Under section 482 of CRPC, huh? If the matter is settled amongst the parties. That's all.
Lordship.
That's all. You are saying your submission is that this court can quash the matter
Lordship, yes,
by
Lordship.
invoking 482, section 482, if
Lordship.
the parties, if the matter is settled by the parties.
Lordship, here in the Kapil Gupta Lordship, in the state of Lordship, Delhi and another Lordship, it's here it's indicated Lordship, the High Court Lordship, to accept the plea component offense based on complete settlement between the parties. It is that the court can also be swayed by the fact that the settlement between the parties is going to result in harmony between the parties. Lordship, as per the I have go to the settlement Lordship. They have twice they have made settlement. One between the complainant and between the victim, and another complainant and between the accused and complainant and later stage Lordship. The victim also they have included. And in the last occasion Lordship, the High Court, the
No,
Honorable Court,
initially it was a victim and the
complainant Lordship,
accused.
accused Lordship, less Lordship.
Second is 3 of them.
The three of them
It's
Lordship.
other way around,
Yes, Lordship.
what you have seen.
Lordship.
Do I have the different documents?
No, Lordship. Lordship, I'm just wanted to say, Lordship, they have managed to, Lordship, come into the compromise, Lordship. And moreover, Lordship, last occasion, the court has raised that issue that if the parties have, Lordship, they have only, last occasion, they have affidavit for the, but Lordship, this, accused Lordship, they have, Lordship, filed the accused, affidavit so that the both the parties, Lordship, authorized him to appear before the court Lordship. But the court has made observation that why not the other two parties, the accused, the victim as well as the complainant. Then after that, we'll Lordship.
Why we are going back to Mughal era? We are disposing of the.
No, Lordship, that's why Lordship, I have made today Lordship, I have not objecting that much Lordship because court has made observation that the Joseph.
They have already filed the affidavit.
Lordship, that's why Lordship.
We have accepted it.
Lordship.
So it's no point going back to Mughal era.
Lordship, that's why, Lordship, I have no that much
Ah.
Lordship objection, Lordship.
Having submitted that the learned additional PP stated that if the offense alleged is heinous and serious, even if there is a, even if the proceeding cannot be quashed, even if there is a compromise between the parties. That is
Okay.
what you wanted to say.
Lordship.
That is Kapil, I
Lordship.
mean, what is Kapil Gupta one?
Kapil Gupta,
says.
Lordship.
All right.
Lordship.
Consider the submission of land council for the parties, and also there is the records. The scan copy, the record of the. Where is the trial court records? Record. Records reveals that the petition number 1 and the petition number 2 were invoked in a scuffle in the wee hours of (23) 02/20/15. Mr. The incident occurred when the petition number 2 was returning after attending the local Yakub festival. At Rono Road. Doimok. The on completion of the investigation, the police has filed the charge sheet. Where is the charge sheet?
Page number 16 to 46.
Hmm?
It start
16.
from page number 16.
Huh?
It start from page number 16.
16.
Yes. (22) and 22 is type of closure.
Charge sheet against the petition number 1 under section 341, 3427, 307 of the 326 IPC. Mr. It is stated at the body the stage of the trial is in evidence for examination of the prosecution witness. Mr. Ajahn, today 4 prosecution witnesses have been examined. Mr. Next para. During the pendency of the criminal proceedings, in bracket supra, bracket close, on 2 occasions, the parties have entered into a settlement, entered into an agreement by settling the matter, Mr. Comma, firstly, between the petitioner number 1 and petitioner number 2. And secondly, amongst the petitioners. By dated 26/1/2018 and 31/08/2023. Next bit. It is noticed that the petition number 1 and number 2 were the accused and the victim. Were in their youthful age of 25 and 26 years at the time of incident. It is also noticed that the petition number 2 was returning after attending the Nyakum festival, where normally, as per the celebration system, in celebrating the festival, certain local drinks used to be taken, but the festival was for celebration of the festival. The incident had happened in the year 23/02/2014. The parties have settled the matter without there being any person and with sound state of mind. They have decided to maintain being a clan brothers, have decided to maintain cordial relationship. In near future. This next one. The quashment of the criminal proceedings on the basis of the compromise under section 482 of CRPC has been laid down by the Honorable Supreme Court. You read this, huh? Which is reported here in bill. Para 15, 15.1. In a case of Kapil Gupta versus State of NCT of Delhi, 2022, SCC online, SC 1030. Honorable Supreme Court has held as under. Para 13 and 14, huh? Next one. On consideration of the matters at entity. Comma. And considering that the parties have settled the matters amongst themselves and to live a peaceful and cordial relationship in near future, comma, I deem it appropriate to. No, I deem it. No, comma, in my considered being. Matter. This is one of the cases where the inherent power of jurisdiction under so and so of CRPC can be invoked. Accordingly, so and so, the criminal petition stands disposed of, allowed and disposed of.
Obliged.
Just come back after 5 minutes.
Item number 7.
May I please, your lordship?
Yes,
Lordship, my senior lacks in another court. Can it be passed over for timing, lordship?
next week. Next week.
The lordship kindly at 2 then.
No.
Next week. In that
Interim may
case,
continue, lordship.
on the prayer of Mr. MS.
A.M. Borbuya,
Yeah.
lordship, I am appearing for A.M. Borbuya.
Burbuya. Huh?
Yes, lordship. Lordship, interim may
Borbuya.
continue.
MS.
MN Borduria is his senior, her seniors council.
A.M. Borbuya.
You are AM Burbuya.
Your name.
I am S.R.
Your name,
Mazarbuya, appearing for A.M. S.R.
Your name,
Mazarbuya.
please.
S.R. Mazarbuya,
SR Mother Buya. SR Mother Buya.
appearing for
MS.
my senior.
SR Mother Buya.
MS SR Mother Buya, Learned Counsel appearing on behalf of Mr.
A.M. Borbuya.
AM Burbuya, Learned Counsel for the petitioners.
Your Lordship, we have received the case diary and this is the original copy, Your Lordship. So in that case, this may be returned and on that day, the same may be called for.
You have no objection.
Lordship,
for-
interim may
Your
continue.
Lordship, objection is there, Your Lordship. My initial objection would be, Your Lordship, they have filed this joint anticipatory bail. Four person in one anticipatory bail. The four have a different role in the anticipatory offense, Your Lord, commission of the offense. So now the difficulty would be, Your Lordship, while considering the involvement of the every accused, Your Lordship, whether it will be possible for this court to consider the involvement of all four accused in one bail application, Your Lord. Wife is there, brother is brother of the accused, wife, another two accused involved in the offense.
Have you raised this
No, this is the first time, Your Lordship. Second time I'm appearing in this case. Earlier, this case was looked after by my sister, Tijine. So earlier it was listed on 6th of this one before this honorable court, and this court was pleased to fix this matter today itself, Your Lordship. So this is
Yes, there's a order of the, have you seen the order of this court? 0605/2024.
yes, Your Lordship. Fixing the test today.
We'll take it up day after tomorrow.
Lordship, interim may continue,
is the-
lordship.
Is this matter on
There, 16.
16/05/2020? Have you seen? the
Lordship,
last order?
interim may continue.
Last,
Because you have made a submission that after obtaining the interim order, they are not cooperating.
okay, Your Lordship.
Take it up. Have you check up the order of last order of this court? 06/05/2025. I mean 24.
Then, Your Lordship,
What is the order? On the prayer of so and so, huh? appearing on behalf of so and so, let this matter be listed on 16/05/2024.
Your Lordship, with a
Lordship, interim order
updated
may
status report,
continue.
Your Lordship. Status report, because the CD status is, it's been filed, Your Lordship, on 6th itself, on 5th. But as on that, there may be some development, Your Lordship, for to ascertain that the
So
status
in
report.
that case, you do list after a week.
Yes, Your Lordship.
In the meantime, the learned additional PP shall obtain the
Updated the status
updated
report.
Status report.
Yes, sir. Deeply obliged.
Interim may continue with Lordship.
Interim order for the election.
And also, will retain the case diary or will send back, Your Lordship?
1 week you can retain it.
Okay, Your Lordship.
You have the original.
Yes, Your Lordship. That is the
How
problem.
they will furnish the.
Your Lordship, yes,
updated
if we
status,
send
you
it,
have the original.
yes, Your Lordship, that is
You
also,
send it back.
we'll send it back and Your Lordship may
the
reflect in
next
the
week.
order, the same may be produced on the next week.
The original case diary produced today be returned and same may be produced on
Next
the
day.
next
Yes.
that week. On the next date of this thing.
Yes, sir. Deeply obliged, Your Lordship.
Obliged, Lordship.
Lordship, this is a bail application, Lordship. Lordship, last occasion, Lordship, the court has asked me to give the status report and whether there is this charge sheeted or not, Lordship. We have sent the Lordship for the status report. We have not received the report yet, Lordship.
You have not received.
Not Lordship.
Why? None appears for the petition on call. MS El Hage Learned additional PP submits it.
Lordship, this may be listed after day after tomorrow. I'll get the information, Lordship.
List is submits that still she has not received the case diary.
Lordship.
Case diary you have not.
Lordship, case diary, Lordship. And the status report, Lordship, whether it is charge sheeted or
matter
not.
after-
Lordship.
After a week, huh?
Lordship, next week, then, Lordship.
Yes, there's the interim.
No, Lordship.
Must have been arrested by now.
Lordship. That's why, Lordship, we have, because this
Then
is,
Friday,
Lordship, it's NDPS matter, Lordship.
huh?
NDPS matter.
Why the way the petitioner is not appearing? After a week.
Lordship. Obliged.
May I please, madam?
Yes.
This item 9 and 15, they arise out of the same FIR. ma'am.
FIR. Huh?
Yes, ma'am. This is Talia PS case number 4 of 24, ma'am.
Yes.
On my lord,
9 and 15.
9 and 15, ma'am.
Hmm.
On 25th of April, my lord, interim was granted
Hmm.
to enable the
Do you have the
applicants.
case diary? Do you have the case diary?
Lordship, I have the case diary for the Lordship, item number 10, Lordship.
Huh?
10.
Why not 9? And 9, 10, 11, 12, 13, 14 are.
No, my lord, 10, 11, 12, it is from the same FIR, madam.
Lordship.
10, 11, 12.
Yes.
Only this case diary is received, Lordship, out of this affairs, Lordship.
10, 11, 12.
Lordship.
And 13, 14?
Not Lordship, not yet.
13, 14 is another FIR.
Hmm.
That is same FIR, 13 and 14. 13, 14 and 16, ma'am.
Hmm. 16.
Yes, ma'am.
13, 14, and 16. So we'll adjourn this,
Ma'am.
huh? Then 10, 11, 12 we will consider.
Ma'am.
Or Mr. D. Soki, Learned Counsel for this. Item 9, huh? MS El Hage Learned Edison PP submits that she is yet to receive the case diary list of according and prays for which she prays for listing the matter after a week.
Lordship.
Mr. Praise the Lord. list this matter after interim order pass earlier and continue, huh? Then, 11,
10, 11, 12, it is out of
that
the
we'll consider now.
arising assumption.
Huh. 13, 14, 15,
13, 9 and 15, my lord, is the same FIR, my lord. Talia PS case 5, my lord,
ah,
of 4, my lord.
ah,
And 13, 14 and 16, it is
ah.
Talia
Yeah,
PSS
ah.
5 of 24.
So 13, 14, 15, 16, same order. Same order, you 9, 13, 14, 15, 16, same order, but in a separate. Right? This after a week, huh? Yeah, 13, 14, 15.
10, 11, 12.
Oh, sorry,
10,
10, 11, 12.
yes.
See, this will be item 9, 13, 14, 15, 16, huh? Same order. But 10, 11, 12, 10.
My lord, this is an FIR, my lord, that arose during the election, my lord.
Hmm.
This applicant, my lord, is an INC supporter.
Hmm.
So at the polling booth, my lord, the BJP workers, my lord,
Hmm.
they were trying to capture, my lord, and they were restraining the applicant from entering the polling booth, my lord.
Hmm.
So during that time, my lord, some scuffle took place, my lord. She's a lady, my lord. And at that time, my lord, during that pushing and pulling, some materials were damaged, my lord. And on 24 or 25 April, my lord, interim was granted, my lord,
Hmm.
to the applicant to appear, my lord, before the IO, my lord. And accordingly, the applicant appeared and was arrested, and the statement also recorded, my lord.
FR page
F-
11.
Yes, 8 start from 8, my lord.
Hmm.
8. 10 is the complaint, my lord, written by the presiding officer, my lord, and type copy is at 11, page 11.
Hmm.
Management. To the officer in charge, Police Station Talia, Upper Subansiri District, FIR against Srimati Nyajum Singham, Mami Singham and Lempi Singham from damaging control unit of parliamentary constituency, voter register from 17A and electoral copy and other election related documents. Respected sir, with due regards and most respectfully to inform you that sir, we conducted mock poll process smoothly and started actual poll process at 7:50 a.m. till 8:50 a.m. Election process was going normal. But around 9 a.m. on Srimati Nyajum Singham and her party entered inside voting compartment forcefully and started damaging voter register for 17A electoral roll, voter slips and control unit of parliamentary constituency. The control unit of parliament has been completely damaged in incident. This is for your kind information, sir and sir. This was by the presiding officer.
Yes.
Accordingly, that case, Talia PS case number 3 of 24 was registered against the applicant's matter in 10, 11, 12. And my lord, here, my lord, the sections, my lord, other than section 3, it has been registered under section 353 IPC, 171C, and 136 IPC, 448 IPC, and section 3 PDPP, ma'am.
Hmm.
Now, only maximum punishment under it is at under section 3 PDPP, ma'am, which is only up to 3 years, ma'am.
Hmm.
And rest, my lord, section 353 is 2 years, my lord. It's non-bailable, but rest of the sections are all bailable sections, ma'am.
353.
353, my lord.
It's non-billable.
It's non-bailable, 2 years, my lord. Section 3 PDPP is also there. The maximum punishment is 3 years only. They've already appeared, my lord, and they will cooperate, my lord. They are cooperating with the IO.
Yes.
Lordship, yes, Lordship, this, as per the CD, their statement been recorded, Lordship. And
Mhm.
as As per the CD case, their statements been recorded. The accused, the three of the accused persons. And Lordship, the case is pending for the seizure of the damage control unit documents only, Lordship.
Huh?
As per the status report, the investigation is pending for the seizure of the damage control unit EVM document.
Who is stopping you to seize that?
Lordship, this is the status of it. Otherwise, Lordship, all the persons, Lordship, they have appeared before IO and gave their statements.
They will make it absolute.
As per the case study, they are cooperating, Lordship, as of now, Lordship. And Lordship, some condition may be imposed that whenever they
Huh?
need, some condition may be imposed
Same
when
terms and conditions.
Lordship.
What is there? Heard Mr. DSOP learned counsel for the petition. The applicant accused.
Yes, madam.
It's this 11, 12 also
10, 11, 12, madam, of the same,
10, 11, 12.
yes, ma'am. Talia
This
PSK,
is Mami Sinkom and Lempi Sinkom.
Lempi income.
Okay, three of them. Name will be different, huh? In all three cases, but then same only. This is an application under section 438 of CRPC, 1974. Grant of privilege of pre-arrest bail to the accused, applicant accused, namely Srimati Nyajum Sinkom, in connection with Taliha PS case number 03 of 2024 under section 448, 171C, 353, 34, read with section 3 of PDPP Act and section 136 RP Act. What is 136 RP Act?
136, my lord, that is maximum punishment is regarding election, maximum punishment is 3 months only, or 6 months only.
Regarding what?
Regarding, my lord, some corrupt act,
Okay.
something like that. 136.
A case has been registered. Being case number, being Talia PS case number 03/2024 under section so and so, pursuant to the FIR lodged by the presiding officer 23/33 Bogia 6 22 Nacho ST Assembly Constituency. To the alleging that at around 9 a.m. one Srimati Nyajum Sinkom and her party entered inside the boating compartment forcefully and started damaging voter register for 17 capital A, comma, electoral roll, comma, voter slips and control unit of parliamentary constituency. It is alleged that the control unit of parliament constituency has been completely damaged in the said incident. There is the case diary. Next paragraph. It reveals from the, it is, there is the case there, next paragraph. It is revealed from the record that the complainant and the witnesses have been examined and their statements have been recorded under section 161 CRPC. It further reveals that during the course of investigation, 3 alleged accused persons, including the present applicant, public accused, Srimati Nyajum Singkom, you have not recorded the statement.
They have recorded, Lordship. It is there, Lordship.
Hmm.
They have recorded, Lordship.
Where it is.
Lordship, it is in the Lordship middle.
This is the statement of the complainant and the witnesses only.
Lordship, this accused persons also been recorded, Lordship. I'm sure, Lordship.
Yeah.
Lordship, not Lordship. Inside, Lordship. They separately they have
Show us
recorded.
the
Lordship.
inside. Don't keep it, keep the inside within you. That is more relevant.
Lordship.
This is Limpis income.
And other 2 accused persons was also there, Lordship.
Limpis income is
Is it
Wait.
item number
12,
12.
Lordship.
Nyajum's income. Have also have been examined and recorded their statements. What is last sentence? Hmm. I have been examined and their statements have been recorded. Next one, it is stated. It is submitted with the Learned Edison PP. Fairly submitted by Learned Edison PP that the accused, the applicant accused is operating with the investigating authority. Mr. Next paragraph. considering the next one, huh? The incident alleged to have been happened. No, and this incident had been occurred during the polling day
Polling.
for the assembly as well, assembly and parliamentary election 2024. At which
33 Bogia Sium polling station.
33 Bogia
Bogia Sium.
That is FIR page 11, huh? 22/33 Bogia Sium.
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 It should be Sium.
SIYUM, huh? Sium 22 Nacho ST Assembly constituency. Just go. Next one. Considering that the nature of the allegations against the applicant accused and the alleged accused applicants is cooperating with the investigating agency authority as well as no further custodial interrogation is custodial interrogation is required. I deem it appropriate to grant the privilege of pre-arrest them to the accused applicant accordingly. We'll make it absolute same terms except the first one. Accordingly, the interim pre-arrest bail granted by this court on 25/04/2024 is made absolute with the same terms and conditions. No. With the following conditions, huh? That the applicant shall accused shall appear before the investigating authority as and when called for, huh? And anything else?
Right, Lordship, the petitioner shall not directly, indirectly make any inducement, treat, or prohibit any person.
That's you, right?
This is earlier they
So
have.
there's two conditions. Anything else?
So the
Any more
petitioner shall refrain committing any similar offense in future.
That I'm not interested. That is not required.
Because otherwise also during the election, so if you come again after 5 years. Problem.
Name will be different, but same. 10, 11, 12, huh?
Right.
Then the interested bail application stands allowed and disposed of, huh? Yes.
And that's this other bail matters is listed after the other bail matters, Lordship, which is a case after it close. Right.
May please, Lordship. My
Yes.
lord, this was came up on 2nd of this month. And at that point of time, the Honorable Justice Gusami has issued a
Yes.
case diary for perusal of this honor code.
You have the case diary?
Lordship.
Ah.
So there was no any interim order stating that the FIR is not at all tenable as per the section 23 and 24 of the RP Act 1951. There are 13 complainants against the petitioner. 13 complaints. So as per the, your lordship, the section 20,
Let us see the FIRs, sir. Where is the FIR? Page 15.
Page 15.
FIR, huh?
yes.
Let's, please read it.
To the returning officer, come Deputy Commissioner, District Namsai, dated 20 March 2024. Subject FIR against YouTube channel Update News for issuing derogatory word against Honorable Deputy Chief Minister Sri Chonamen and Susanna Namchum, BJP party official candidates of 48 Likang ST Assembly constituency. Sir, respectfully, we on behalf of BJP party of 48 Likang ST Assembly constituency
Yes.
would like to draw your kind attention regarding the news item of YouTube channel, namely Update News. In the news item, it is clearly mentioned that Sri Chonamen, Honorable Deputy Chief Minister, is anti-Assamese and Likang, and he has been done nothing for the welfare of the people of Likang in his 25 years of tenure of Likang. Now the Honorable Deputy Chief Minister is sending his close aides, namely Susanna Namchum, who is also a anti-Assamese, to Likang as candidate of BJP party. Sir, such news item may create misunderstanding among the innocent voters of 48 Likang ST Assembly constituency and may lead to communal clash and law and order problem in 48 Likang Assembly constituency at the time of election. Considering, we pray your honor may kindly take appropriate action against the news channel, namely Update News. This is for favor of your kind and early action, please.
Yes.
So it was received.
Lordship, as per the Lordship, CD Lordship, they have Lordship made the complaint Lordship after the investigation was carried out. And Lordship, now they have searched for this complainant or this accused person Lordship, is evading the arrest Lordship. Lordship, today Lordship, last August CD was called and Lordship, he may be appear before the IO Lordship for his statement.
Where is the CD?
This CD Lordship.
What does it say? He's evading the arrest.
Lordship,
Is it required to be arrested? Once
Lordship,
a FIR is registered?
Lordship is
Is
registered.
it the law?
No, this is registered, but Lordship, they have, as per this Lordship, this CD Lordship, they have just investigating the case Lordship now Lordship. It is under investigation Lordship.
Well, one thing very very pertinent question.
Yes.
Under section 123, subclause 3A, it says the promotion of or attempt to promote feeling of enmity or hatred between different class of the citizens of India on ground of religion, race, caste, community, or language by candidate or his agent or any other person with the consent of minor.
Why you have made party this respond number 2, 3, 4 unnecessary? And 5. State
IO,
and-
IO of
state-
the case.
State is there.
IO of the
It's
case.
more than enough. Why this person should be there? In that case, we will have to issue a notice.
IO minor.
Not only IO, all of them. 2, 3, 4, and 5. 2, 3, and 4.
It was not required, Your Excellency.
State is enough. PP is representing the state.
Yeah.
Heard Mr. T. Sir, learned counsel
Minor,
for
this is a
this.
pit case where the interim direction is
No,
necessary.
interim will dispose of this, will
Yes.
allow. But you have to appear.
Yes. In the
With
event
certain
of minor's
conditions.
appearance, he
Yes.
should be released on bail.
Heard Mr. T. Sir, learned. Well, what about these persons? 2, 3, and 4? Let us see the CD. Heard Mr. T. Sir, learned
2,
counsel
3,
for the
4.
petition.
They are the complainants,
They are
Lordship.
the complainant, minor.
Their name has been reflected in the FIR also, Lordship.
Also heard MS El Hagi, learned counsel, learned additional PP for the state. Expert. Apprehending arrest in connection with
Likang PS case.
Mahadev,
Madhepur PS.
Mahadevpur Police PS case number 08 of 2024 under section 153A IPC. Read with section 123 within bracket 3A, bracket close within bracket 4, bracket close, and 125 of Representation of People's Act 1950. The applicant accused has filed this application for grant of free arrest, privilege of free arrest bail. An FIR has been, the above FIR has been registered pursuant to the lodgement of the same by 13 persons on 20 03/2024. Alleging that the YouTube channel, namely within inverted comma, update news. It is update news or update now?
Update news.
Updated. In case there it says it's updated, update now, update news.
It's update news, Lordship.
Stating that the channel has clearly mentioned that Sri Chounaman SDCM is anti-ASMES and anti-Lekang, and he has been done nothing for the welfare of the people of Lekang in his 25 years of tenure at Lekang. And the SDCM is sending his close aides, namely close aides, who is also anti-ASMES to Lekang as candidate of the BJP party, BJP, candidate of Bharatiya Janata Party in the It alleged that the said news would create misunderstanding among the voters of 48 Lekang Assembly constituency and may lead to communal clashes and no other problem during the time of election. Mr. Registration of the above FIR. The investigating authority during investigation prepared the transcript of the contents according to which it is found to be promoting enmity, hatred on the ground of community, race, etc. Where is the case diary produced by the learned additional people? On the perusal of the case diary. Next one, huh? It transpired that the transcript of the contents of the alleged video appears to be amongst others. Promoting enmity, disharmony. Amongst the different communities, which needs to be ascertained as it needs to be ascertained. if it is if the same is true and which has been projected to the YouTube news YouTube channel, namely Update News by the applicant
Yes.
is is a serious concern. Mr. However, since the petitioner is ready to cooperate with the investigating authority. Come on. The I'm of the considered with the accused applicant is entitled for privilege the prior's bail. Accordingly, in the event of arrest, the accused applicant accused, namely
Religion bail.
Hiran Moran. You are the YouTuber,
Yes,
huh?
yes.
You are from Tinsukia.
Tinsukia. Covering entire northeastern region. Covering entire northeastern region.
Hiranmoy Moran shall be released on bail on furnishing a bail bond of rupees 30,000.
5,000. No, this is a special case, a special act, my lord, under the RP
150.
Act, my
No,
lord.
153 is there. As per the CD, parenthesis 153A is attractive.
Okay, my lord. It is written.
20,000. 20,000. You are a YouTuber, big man. 20,000.
20, my lord.
With
20,000.
with two local surety of the like amount to the satisfaction of the arresting authority. Mr. On the following conditions, the petitioner shall appear before the investigating authority within 7 days. Within 7 days from today. And in the from today, Mr. Failing which the bail this order shall still vacated from the 8 days from today. Shall not have any force from the 8th day. Mr. Then same condition, they should not hamper or tamper with the so and so. The petitioners, the accused applicant shall not leave the jurisdiction of
Mahadevpur.
Yes.
Mahadevpur.
Mahadev
Police
PS.
station.
jurisdiction of What magistrate?
Oh, Lordship, this is judicial magistrate, Namsai, Lordship.
Namsai,
Namsai.
judicial magistrate, CGM,
CGM?
CGM.
CGM is Lordship. JMFC,
JMFC.
Lordship.
Ah.
JMFC.
Jurisdiction of the JMFC Namsai with their prior permission.
Obligation.
Will it be possible?
I'll convey my lord.
Obliged, Lordship.
The bail application stands allowed and disposed.
CD may be sent back, Lordship.
Ah. Send down the case diary. We'll resume at 2.
So far as the FIR is concerned, their name is not there in the FIR. However, during the course of investigation, when 161 statement of the victim is recorded, it's clearly identified both the accused name, Your Lordship. And so far as the other witnesses is concerned, regarding the commission of the incident has been confirmed by the other witnesses. But Your Lordship, so far as the statement of the victim, there are, including these 2 accused, there are other 2 or 3 accused person were there in the place of occurrence, and they were subjected him to this assault. And as per the statement, both the statement of the accused has been recorded, but they have denied their presence in the place of occurrence. Since they are denying, so they are not disclosing the name of the other co-accused, Your Lordship, who was involved in the incident.
The accused?
Yes,
The
Your Lordship.
applicant here?
Yes, Your Lordship.
Well, wouldn't it be the person who has been alleged victim should identify who has assaulted him? We are denying everything. The FIR is at page 15.
Yes.
This is specifically against my elder brother, who was the BJP contesting candidate from 8 Bamek. Now, one of the person's name, this is by some other person, Dongro Saria, he has implicated me, madam. But in terms of an interim order passed by this honorable court, madam, we have already appeared. Madam, is this a case, madam, where custodial interrogation is necessary? I am a government officer also.
With an injury report?
Injury report
It's
is not,
not serious injury also.
injury report is not there in the case diary, Your Lordship.
There is no injury.
Injury is there, Your Lordship. So far as the statement and statement is concerned, she was evacuated to the hospital, Your Lordship. So if Your Lordship, if there is injury, then in that case, Your Lordship may direct to produce the MLC, Your Lordship, if any.
Madam, my instructions are there are no serious injury. 307 has been mechanically inserted.
If 30 is there and if there is no injury, not even a prescription.
The CD in CD, Your Lordship, nothing has been annexed. Only
There is no.
only the statement has been recorded.
Other person is not even a victim.
So, Your Lordship, at this stage, in order to ascertain whether there was any injury or not, in that case, Your Lordship may direct to produce the MLC if there is any medical report is there.
Said by the IO, if it deems it that the medical report is not there,
Your
I think
Lordship,
will be subjected to such.
because, Your Lordship, as per the case diary, it has been stated that, Your Lordship, the present victim was badly beaten by some unknown person, and injury mark on their body part. With help of police personal security present, they have shifted the injured person to the hut and called ambulance from district hospital. Then definitely, Your Lordship, this medical report will be there, which is no doubt not a part of this case diary as on that, Your Lordship.
Madam will consider whether custodial interrogation is required or not. We have appeared before the police, we have given our statements. Apparently, the alleged victim is fine now.
That's the reason we would like to know why, what is the status of the victim?
Status of the victim. Your Lordship,
What is the injury, the nature of the injury and,
yeah, here in the, Your Lordship,
FIR doesn't say anything. on
yes,
that.
Your Lordship, absolutely, Your Lordship. Here, okay, in case diary, Your Lordship, no doubt.
Brutally beating.
Regarding Your Lordship, the injury, they have mentioned that the person has sustained injury and he was evacuated to the district hospital, Seppa. But to that effect, Your Lordship, injury report has not been annexed in the case diary.
Why not annexed?
That, Your Lordship, I don't know, Your Lordship. For that, Your Lordship, otherwise, Your Lordship may fix a next date so that we can punish the MLC if any is there, Your Lordship. Otherwise, Your Lordship, so far as the statement is concerned, Your Lordship, the incident has no doubt it has been taken place at the Sharia polling station, wherein the present accused, they have assaulted the victim along with 3 other persons. But the 161 statement of the
It's okay, it's a matter of investigation and trial.
yes, absolutely, Your Lordship.
Where on bail jurisdiction?
Here, Your Lordship, the question here is, so far as Your Lordship, this custody interrogation is concerned, the prosecution has to show that there are whether they are cooperating with the investigation or not, basing on the material. So now, so far as the statement is concerned, they have been identified, and the other witnesses they have clearly stated that the incident has happened. Incident is not disputed; that has happened. And the identification of both the accused has been given by the victim itself. The name has specifically given in the 161 statement. But both the accused, 161, they are denied their presence in the place of occurrence. And they are not disclosing the name of the other co-accused. Since they are denying, they are not disclosing the name of the other co-accused, Your Lordship.
Obviously,
For that custody interrogation, Your Lordship,
My lord,
is required, Your Lordship.
election dispute, my lord.
how he can be forced to disclose if he's denying that he's not involved?
That is what, Your Lordship, my humble submission is, Your Lordship. The victim has clearly identified the accused. And on the strength of the interim protection, Your Lordship, they have appeared before the IO. And
Friday,
My lord,
we'll ask for the
Injury-
MLC, if any.
My lord, I have to go down to Guwahati to have my daughter admitted to school.
Friday.
I don't know, because there's no need for custody interrogation, my lord.
No, that I have seen. I agree with you.
I can,
Since
how can
it's
this be a case? that
307.
When I'm
I just-
denying, you say
Just
that I have
would
to
like
disclose
to-
when I'm denying the incident.
But it's very strange why brutally beaten up on 307.
Your Lordship,
Don't have the MLC.
perhaps they may have inadvertently missed out to annex the injury report, Your Lordship.
At
In
least
that
the
case,
injury report should be there.
Your Lordship, because so far as to attract the section 307, Your Lordship, no doubt regarding the injury, they have stated in the case diary, but report has not been annexed, which we are seeking to punish on the next date
Let us see.
if anything is there.
Who
But
is-
so far as
who
Your
is
Lordship,
statement?
to Your Lordship, From there,
Police is also saying,
because Your Lordship, to attract the section 307, the injury inflicted to the accused is immaterial. It's only the knowledge and the intention, Your Lordship, to attract section 307.
The nature of the allegation you had in the FIR.
Since Your Lordship, the FIR is not doesn't disclose the entire fact, Your Lordship, that can be ascertained from the case diary only, Your Lordship.
this cannot be only one way, madam. We are saying this is a politically motivated FIR. How can my learned friends COD said I was there just on the basis of a statement made by this person? It is not for me when I'm denying. How can I disclose someone when I'm not there?
Your Lordship, the statement is well settled that the statement of the injured victim cannot be questioned the credibility of the
Ultimately, it's a matter of investigation.
injured
my lord.
victim, Your Lordship.
Why don't
Injured
you
witness, Your
see, the person named my lord specifically, he is not arrested. Now, the brothers are roped in.
In fact, Your Lordship, the main named accused, there is no any material against the name accused, Your Lordship. There is exculpatory statement against the main accused.
That itself, my lord, will show that the FIR is motivated. Specifically, beating by such and such any supporter.
Where's the statement of the accused?
Accused, your lordship, I marked this pink color, your lordship.
one?
Yes. So, they are flatly denying their presence at the place of occurrence.
The accused is a businessman.
No, I'm a junior engineer.
Two accused, your lordship. Two bail
One
applications.
is a political interpreter PI. This one, man, this item is a junior engineer. Railroad Department,
This is
18.
18. Ashok Lamio.
Ashok Lam.
This is the junior engineer.
Where is that? This is the, who is it? Okay.
I don't know what is there in the case diary,
Okay.
but I-card man, I have annexed in Annexure 1. Page 11.
This next case is
This is also one of the brothers.
Tagum.
Tagum
He's
Lamio.
the businessman.
Yes, Tagum.
Huh?
He's a political interpreter, man. Yeah.
He said he's the businessman.
Tagum Lamio.
Maybe doing business also.
Tagum Lamio. He said, I'm a businessman by profession.
But he's also a PI, my lord. I have annexed page 11.
The statement of presiding officer is also there. There is no dispute regarding the incident, your lordship, on Sangyo polling station.
Where does we find that they were there? What is the statement of that?
It's there, your lordship. May I find?
Hmm?
The polling station, polling officer has not identified, but
That statement will be in respect to this Dongro Saria.
But-
I have a categorical case.
but your lord,
Political work of the opposite party, he has
Your-
implicated me.
your lordship,
That is why we are before Lord.
it's an injured victim, your lordship, and your lordship is aware about. It's not a trial, no doubt, but your lordship, even at the stage of the investigation,
I'm just
considering the
pointing
bail,
out
your
it is in
lordship,
the statement of Dongro Saria, my lord.
it's a-
Hmm.
He's a
it's
political
victim.
opponent.
It's an injured witness.
Anyway, all these are arises out of all this election related matters. Let there be investigation and let this accused applicant to cooperate with the investigation. That's it.
I will leave up to your lordship.
Think not seriously.
Otherwise, your lordship, my only concern is, your lordship, since they are denying and the other accused were also there. No doubt it's a because of political rivalry, the dispute has happened, but someone has sustained injury, your lordship.
That is your lookout. You find out the real culprit.
Your lordship, for that, your lordship, the custody interrogation of these two accused, because they are not cooperating, they are not disclosing the other person name who involved, and they itself is denying their presence, your lordship. Because your lordship, investigation has to be carried out on the basis of the statement given by the victim and the other witnesses, your lordship. The other witnesses clearly confirm the commission of the offense at the place of occurrence, and the
My lord.
victim itself has disclosed the name, despite their name has not been there in the FIR.
I don't understand, my lord. I have given my
Where
statement
it
denied.
has been disclosed.
So what do the police
No, Your
propose
Lordship.
to do? Arrest me and use my
Name-
degree on me or what?
Name
What
has been
kind of submission is that?
name has been disclosed by the victim, Your Lordship. Your Lordship has already perused, perhaps, Your Lordship.
This one.
The victim statement. This is the victim, Your Lordship. Saro, Dan,
Sorry, oh, sir.
Sarios.
That is our whole case, my lord.
No, this is one Vishnu Cheda.
In second page, Your Lordship. Second, Your
No,
Lord,
sorry.
Your Lordship, it's marked with green page, green plague mark, Your Lordship. The statement of the victim.
Dongro, sorry.
Last one from bottom, Your Lordship.
How is the victim? Any idea? Anything here? Nothing.
No idea, Your Lordship. Case
Injury
diary,
and all,
case
nothing.
diary doesn't reveal anything.
The statement of the victim only.
Yes, Your Lordship. And case, Your Lord, investigation will be progressed on the basis, initially on the basis of
Yes, they will cooperate.
that I will leave it, Your Lordship. Otherwise, Your Lordship, my objection is regarding Your Lordship, since they have denied and the disclosure of the name of the other accused is not possible without custodial interrogation, Your Lordship. In this kind of cases, Your Lordship.
I'll point out, my lord, two other persons were in fact arrested by the police
Hmm.
at page 16 and they have also been granted bail.
16.
Yes, 16 and 19. No materials were found against them. Police are randomly arresting, my lord. After all, this is the investigation job, agency's job, to find out, my lord. They cannot say that it is my duty when I'm denying the crime. I'm denying the accusation. But how can it be a case that I should be the person who is supposed to name the accused when I'm denying my very presence? In any case, my lord, will ultimately see his custodial interrogation required, my lord. As I was pointing out, my lord, the FIR itself is motivated. It was filed closed by the election agent, specifically naming some person. Who has now found, it has been found that he is not involved.
These two persons were arrested.
Yes. Order Lam News.
Will grant you, but then since the accused has, as a victim has particularly clearly taken your name, you appear every week for a month before the
Fine.
IO. Okay. All right. Every month, once in a week,
For a month.
for a month.
As and when required, actually, your lordship, even if it is not required, if they are not required, your lordship, the restriction imposed for at least for the month, they have to cooperate, your lordship. And even if IO required, then the authority may be given to the IO, your lordship. As and when required, they may appear before the IO, your lordship, for the
That's all.
investigation. Yes.
I'm putting a more stringent condition. Every week, once in a week for 1 month.
Thereafter,
Thereafter, as and when.
I have no objection.
All right.
I will leave it to your lordship.
Because actually, we're conscious if the injuries are serious and all, we'd like to see the MLC report, but you are not able to.
Your lordship,
You have not, if there is any event for a prescription.
your lordship, I'm praying for further time so that we can produce the MLC if so required, because they are in interim protection, your lordship. There is no.
Otherwise also, even if you produce also, we'll have to grant. What do you say?
No, in the matter of grant, I have some personal difficulties also. I'm accepting the conditions, my lord. 1 month every week I will appear.
Because your lordship, it's a anticipatory bail, the privilege bail, your lordship.
Yes.
So your lordship, the bail, anticipatory bail, if material everything is there, and if we
And
establish
after you come back, you take up the matter after you come back.
That is the why, my lord.
if we saw more
You
than
are on
prime,
interim.
I understand
are-
that, my lord.
You have been released.
I'm
on-
making a prayer, my lord will consider, my lord, if your lordship feel that it should be extended, I have no objection. Otherwise, my lord, it's a election matter, my lord.
I understand.
What is the purpose of my lord custodial interrogation?
but
What will you do? Beat me up or what?
it's not. But injury is there. Somebody has sustained injury, your
That's
lordship.
very well, my lord. He's must be obviously well.
And-
He's giving his statements before the police.
And your lordship, section is not 325 or 326. It's 307, your lordship.
No, that's what I'm saying.
So for that,
But
your
why you are so casual in
Yeah,
with the.
It is not my fault, my lord.
Production of the.
Your lordship,
I always not
for,
sent it.
for that I'm praying, seeking time so that we'll produce the MLC if so required.
Let's
your
do
lordship.
one thing, when you would like to list it, let him produce, we'll consider.
My lord, I am not very sure, my lord. That is the difficulty.
Let it after 2 weeks.
No issue, your lordship.
2 weeks or 3 weeks, whatever. By the time things might have settled.
Let it be on 22nd, my lord. If I am available, my lord, I will do it.
22nd.
27.
But my lord, I am making a prayer. It is the job of the IO to, my lord, send the injury report, my lord. How can they be so casual, my lord, and what is that?
Your Lordship, this is for the first time after interim protection, Your Lordship. If I
I
has,
understand that, but the CD has come
Yes.
without the, my lord, it's 307 case. Am I to understand that the IO doesn't know the value of the, my lord, injury report?
Even if there is a injury report, but then we'll have to consider on its own merits.
Yes,
Okay.
But then, for the satisfaction of the court, the extent of injury would like to know.
intention and knowledge has to be looked into. It's a 307, Your
Okay,
Lordship.
we're not on trial now.
Yes,
Exactly, my
It's a
lord.
base jurisdiction. We'll understand, but then we need to.
that can be called out from the Your Lordship, the material collected during the
have to
course.
satisfy
My lord,
ourselves.
that I understand, my lord, or your
Yes.
lordship, it is, you have to, lordship will say by yourself. But my lord will see the nature of the FIR. They are not saying he was grievously hurt. And apparently he is fit enough to give statements, my lord.
Brutally beaten.
In the FIR, my lord.
Yes.
They have just brutally beating by such and such.
Hmm.
This FIR itself is motivated, my lord will see who they have named.
That we understand. We understand, but then see, let us give them a chance so that tomorrow they should not make a complaint.
Ultimately,
No, considering
submitting,
that
my lord.
otherwise,
How can the IO be so casual?
considering that you are under interim protection,
Yes, yes.
otherwise you
Yes,
should
yes.
have, because you cannot, we would not have allowed you to suffer. Okay, heard Mr. Deepang consent for the petition. Mr. T at the learned additional PP has produced the case diary. Except for the recorded statement of the victim and the complainant.
Yes.
Victim-
No,
Victim,
not
victim,
complainant.
victim, Your Lordship.
Alleged
Who is
victim.
this? No, alleged victim and what is the other one? Tayyip Sonam. Who is Tayyip Sonam? Complainant.
No, man. Tayyip Sonam, yes, he's the complainant.
Complainant,
Yes.
informant.
Election
So,
agent.
except for the statements of the complainant, no, accepted.
Victim.
Case diary only consists of the statements of complainant, victim, and the applicant accused. The nature of the allegation is such that the MLC report ought to have been placed before this court. However, no MLC report, no MLC, much less the prescription,
Yeah.
doctor's prescription, medical prescription
Medical prescription.
is not available. Mr. T is directed to produce, if any, the MLC or prescription, medical prescription
Yes.
on the next date fixed.
Your Lordship, maybe along with the updated case diary, Your Lordship. Maybe along with the updated case diary, Your Lordship.
Along with updated case diary.
Yes, Your Lordship.
List this matter on
Let it be on 22nd, man. I will see if I am.
22nd, 22/05/2024. The interim order passed earlier shall continue. Interim bail granted by this court.
In item number 19 also.
90,
19, item 19. 18 and 19. Voter brothers.
0305. Interim
Yes.
bail is 050.
No, I'm saying item number 19 also. Same.
Okay, 0305. Shall continue. Both the cases.
Same order.
CD return, Your Lordship. Deeply obliged.
Service completed, Lordship. Finished service.
Office note, Mr. or Mr. Arigo, learned counsel for deputation. Also. MS El Hage, learned additional PP. Office note dated 2024 reflects that the service report in respect of respondent number, service on respondent number 4, service of notice on respondent number 4 is completed. List for admission hearing after 2 weeks.
Lordship, I have an interim prayer.
Interim order passed earlier shall continue.
Lordship, interim was not there, but
Interim was not
I have
there.
an interim prayer.
Then after 1 week,
Yes.
after
the-
1 week.
Yes, since the investigation is going on before this.
We cannot stall the investigation. Then will you renew your prayer after 1 week? This is for admission. In that case, list this matter after a week. List of the admission hearing. This matter after a week for admission hearing. On that day, you may continue.
Last Lordship.
Definitely.
Who is this?
My lord, here in this case, excess of pleading has completed, so
Ah.
the matter is ready for hearing. So this can be picked for admission hearing in the next week, ma'am.
Where is IA?
My lord, I is filed by the respondent, praying for vacating of the interim order passed by.
Yes, you
this
have not
honorable
filed
court.
any objection.
Yeah, I have already filed.
You have filed
Yes, I filed this morning.
today.
Yes.
Have you received the copy?
I have received the copy. However, in the IA, what they have said is, it's already in the, they are ready to, since the pleading is complete in the main case, so they have not objected anything. Since the pleading is completed, therefore, the main case may be disposed of. However, in my IA,
It
the
amounts to no objection.
yeah.
My
It
lord,
amounts to no objection.
no, objection is there, my lord.
And
Then
other
what is the ground of objection?
My lord, basically, my first ground is that this is the IA, wherein my lord, no
Okay,
any substantial
service
matter has
completed.
not been annexed.
No, this one. This is for today, for consideration of IA.
Of course not, my lord. That the whether IA has been replied, on the
pleadings are-
last occasion,
Buildings are completed.
Lordship, IA
Yes,
was filed in the
admission.
month of March. Actually,
After a week.
my lord.
What is the stay? What is the matter?
So for matter is concerned, my lord, the impute before the lordship is the order passed by the ADC Nari
Hmm,
on 18/9/2022,
hmm.
whereby my private constructed gate was directed to evict it.
Hmm.
Therefore, my lord, by not concerned with the order passed by the ADC, this case has been filed.
Hmm.
Now, my lord, the ground behind the filing of this, my lord,
Eviction notice, eviction order.
eviction order.
Who is the respondent? How is he connected?
My lord, the so far, my lord, the so far brief is concerned.
So
There-
this
Out of the land dispute, there was
matter
a
relates to land dispute.
manner. There was a land dispute since 2001. That dispute was adjudicated in the Blaise level
Hmm,
on 15/6/2019.
hmm.
And accordingly, the KEBA decided in my favor.
Yes.
Therefore, since 15/6/2019, I am the judgment degree holder of
Yes.
the KEBA decision.
Hmm.
Despite of appeal the KEBA decision, that KEBA decision was not appealed by the respondent. In fact, the respondent has tried to appeal, but that appeal was not accepted.
Hmm.
In due course of the time, what the respondent has done, after losing in the KEBA forum, she had erected the permanent wall. In fact, at the time of the decision pertaining to the KEBA, that was the bamboo wall. Therefore, my lord, execution was filed, and execution was filed before the ADC Nari. and accordingly that execution petition was disposed. In view of the execution petition, that order was passed by the ADC Nari to dismantle or demolish the the wall erected by the respondent. Thereafter, my lord, out of the execution petition, now that disputed area become undisputed and that's become my private land. Therefore, my lord, for my protection, that I have erected the iron gate. Now, the respondent.
Yes, you have erected an unauthorized iron gate obstructing the pathway of Nari village.
My lord, this is what the respondent has projected. But this is not the case of the Nari village, or not the case between the Nari village and the my lord. This is only, the case was only confined with between the petitioner and the respondent, my lord. So, my lord, if my lord is ready to dispose of the matter, then they should be hard in land. Otherwise, my lord, my prayer for today is that, my lord, there is
15/7/2023. Where is this order?
my lord.
15/7/2023.
Lordship, execution order. Lordship,
Yes.
the impugn, the order impugn has no relevancy with the submission made by my elder. Because the order
I'm ready
impugn is in connection, is the continuation of execution order passed
What is the
by
order?
the ADC Nari.
It's okay. This
So-
will, you
so-
started work it out on last. We're fixing it
Because
for,
because
fixing
he has
it for admission hearing.
Lordship, because he has erected iron gate just adjacent to my gate only, which is 200 or 300 meter away from her residence. And
Okay.
she has her own motorable road, everything she has. Nari ADC directed me to remove remove my fencing. I have removed. After my removal, she has erected iron gate, citing that residential area of Gibom Bomjen, who is the father of the petitioner.
Hmm.
And there was no land dispute. It was dispute only on the footpath of the public footpath. At no relevant of time, there was series of litigation. The title is in my name. Title was never a dispute. However, the dispute was only with respect to the footpath.
Hmm.
So after compliance of everything, I have removed my RCC structure.
Have you filed objection to the CRP?
I have filed my counter.
Okay. So pleadings are completed. List for admission hearing after a week. If on the next date, if the main petition is not taken up for admission hearing, taken up for disposal, the IA filed by the respondent shall be considered and disposed of. In case on the day, if it cannot be disposed.
Well, till an interim order pass earlier, we can,
Okay. After a week, right?
no problem.
Interim order passed earlier shall continue.
Much.
Bye-bye.
Number 23.
My lord, and main appeal notice was issued, my lord, and records were called for. Today, my lord, I'm praying that the IA which we have filed under section 489 for suspension of sentence and releasing the accused person on bail.
Service not complete.
My lord, form of 389, my lord, services. No, I don't think service would be
This
required, my lord.
section,
IA, my lord.
section,
The
What is the offense?
Offense, my lord, there has been 3 years imprisonment only.
Hmm.
It's not a heinous offense, but therefore, notice the public prosecutor is also not necessary. my lord. As per section 389.
We'll wait for some time.
He is more than 3 months now in custody, my lord.
Original
Your lordship sees the provision of 389, my lord. It was convicted on 21st February. No, section 389 provision, my lord, is very clear, my lord. Because he was already on bail during the trial period. He used to be released on his one personal bond.
When the steps were taken? Steps. 13-3.
Yes.
Let us wait for some time.
Records,
Two weeks.
one of the
The record is there. It picks up to 2 weeks. Wait for some time.
because of this ought to, I ought to have been considered, my lord.
No, we'll consider. Definitely.
Can it be considered after being one of this hard pressing because he was a student, my lord.
Huh? Student of what? Which class?
My lord, nowadays your lordship is aware, my lord, they don't retire from student leadership.
Huh?
He is also a member of the East Coming Students Association.
Students of school or college?
So college, my lord, college.
Are you ready? 389.
Well, I'll just, lordship, I'll just,
We'll take it up tomorrow.
yes, sir, 2-3 points only, my lord. Yes.
There is a student and not serious and heinous crime.
Yes,
We'll see tomorrow.
Lordship.
oblige.
You come prepared.
Lordship.
Let this matter on 15. 15-050.
Oblige.
My lord, your lordship wanted to know about whether the statutory appeal, when it's
Ah.
pending, can be taken up.
Hmm.
Lordship,
This cannot be taken up.
no, it can be, my lord. The inherent jurisdiction can be invoked at any stage, my lord. It's 2022-14 SSC, my lord, but we have printed it in the Supreme today, my lord. The equivalent citation is 2022-14 SSC 531. That's there, my lord. So here, Malab, in this matter, there are 2 cases, Malab. One from Madhya Pradesh and another from Karnataka. It was taken up together by the Honorable Supreme Court. 2 cases. So in this, it was decided that 482 can be invoked at any stage in the non-compoundable cases.
Punjab and Haryana.
Malab?
What is this? Punjab and Haryana?
No, Malab. The Supreme Court, Ram Gopal and another was versus State of Madhya.
Okay.
Yeah.
Hmm.
The Supreme Court's.
Hmm.
Here, Madam, your lordship will find at page 4, Madam. The brief text 4 of 10, Madam, down below. Page is down. Yes,
Hmm.
lordship, para 2, Madam. Here, what happened, Madam? This accused person was convicted by the trial court.
Hmm.
And the appellant asserted that one before the additional session, and during the appeal, the petitioners and they reconciled, compromised. But and the sentence was reduced, and only because 326 is non-compoundable, the learned additional session judge didn't allow that to be compounded, and they went to High Court, challenging filing an appeal and also revision, saying that as we have compromised, we want to compound. High Court didn't allow compounding, saying that 320 is non-compoundable, it cannot be done. Therefore, they approached the Supreme Court. Para 13, lordship. Here. And next is, story, brief facts would be different because that is from Karnataka. We are concerned with the first case.
Just wait.
High Court though reduced the sentence to already undergone by the appellant, but didn't allow the compounding of the case under 482. So now Lordship will direct come to para 13, page 6 of 10. It appears, Lordship,
Para?
13.
Yes.
It appears to us that, Lordship,
Yes.
the criminal proceeding involving a non-heinous offence or where the offence are predominantly private nature can be annulled irrespective of the fact that trial has already been concluded or appeal stands dismissed against conviction. Handing on punishment is not the sole form of delivering justice. Societal method of applying laws evenly is always subject to lawful exceptions. It goes without saying that the case where compromise is struck post-conviction, the High Court ought to exercise such discretion with rectitude, keeping in view the circumstances surrounding the incident, the fashion in which the compromise has been arrived at, and with due regard to the nature and the seriousness of offense, beside the conduct of accused before and after incidents. Touchstones of exercising extraordinary power under Section 482 CRPC would be to secure ends of justice. There can be no hard and fast line constricting the powers of High Court to do substantial justice. A restrictive construction of inherent powers under Section 482 CRPC may lead to rigid or spacious justice in which in the given facts and circumstances of case may rather lead to grave injustice. On the other hand, in case where heinous offences have been proved against perpetrators, no such benefit ought to be extended as cautiously observed by this court in Narendra Singh and such one. And para 14. In other words, grave, serious offences or offences which involve moral turpitude or have a harmful effect on societal and moral fabric of society or involves matter concerning public policy cannot be constituted betwixt two individuals or groups of only. For such offences have the potential to impact the society at large. Effacing abominable offences through quashing process would not only send wrong signal to the community, but may also accord an undue benefit to unscrupulous habitual professional offenders who can secure a settlement through duress, stress, societal bypass, bribes, or other dubious means. It is well said that let no guilty man escape if it can be avoided. So 15, Madam. Given these settled parameters, the order of the High Court of Madhya Pradesh culminating into criminal appeal number such and such, to the extent it holds that the High Court does not have power to compound a non-compoundable offense is in ignorance of its inherent powers under Section 482 CRPC and is thus unsustainable. So, the Honorable Supreme Court says any stage can the 482 can be invoked. Rather, in our own High Court, one in such a case said matter should be pending, then only inherent jurisdiction can be invoked. So rest after that is discussing the second case, madam. So this is the at any stage.
Yes.
And the Punjab, there's a division bench of Punjab. Vichitra Singh, madam. Your Lordship, here para 7, madam, it is specifically is about the matters pending in appeal. Lordship got para 7.
Same, your case is also T26.
murder. Here, para 7, this would be relevant. As per the division bench judgment is such and such and such and such, it is held by this court that compounding offense at the appellate stage is permissible on the basis of compromise invoked by the power under section 482, even after conviction of the accused person by the trial court and during the pendency of the appeal against such conviction, and following questions were framed for consideration therein. Here, two, madam. First condition was whether power accessible is controlled by section such. That's different, ma'am. Two, whether criminal proceedings can be quashed by the High Court in exercise of its powers under section 482 CRPC, even after the accused was found guilty and convicted by the trial court, though the matter is sub judice before the appellate court. And this was answered in affirmative manner. Down. So division bench of Punjab and Haryana High Court is also affirms it can be 482 can be invoked at any stage. Even during the pendency of appeal.
Where does it say?
Malat.
Para 17.
Here,
16.
Is quoted, 16. There's a earlier judgment. It's quoted earlier judgment. Para 16 is quoted. As regards to doubt expressed by the learned single judge whether the inherent powers under section 482 CRPC to quash the criminal proceeding on a basis of compromise can compromise entered into between the parties can invoke even if the accused has been held guilty and convicted by the trial court. We find that in such and such, the unfortunate matrimonial dispute settled after appellant husband had been convicted under section 498A and sentenced to 18 months imprisonment. And his appeal was pending before the first appellate court. The apex court quashed the criminal proceeding, keeping in view the peculiar facts and circumstances of the case, and in the interest of justice, observing that continuation of criminal proceedings would be an abuse of the process of and also by invoking his power under Article 142 of the Constitution. Since the High Court does not possess any power akin to one under Article 142 Constitution cited, the decision cannot be construed to have vested the High Court with such like unparalleled power. The magnitude of inherent jurisdiction exercised by High Court under Section 482 CRPC with a view to prevent the abuse of law or to secure the ends of justice, however, is wide enough to include its power to quash the proceeding in relation to not only the non-comparable offences notwithstanding the bar under Section 320 CRPC, but such power in our considered view is exercisable at any stage, save that there is no express bar, and invoking of such power is fully justified on facts and circumstances. Any stage, invoke. My first leg of argument is that
this honorable court has the power under 482 CRPC to quash the conviction that has already been done by the Honorable Supreme Court,
Yes.
Honorable trial court. But my alternative prayer, if your lordship finds that this section 3, it definitely is non-compoundable, 457 both. So in that case, my lord, I have yesterday, I once again brought that also 2008-15 SCC, 667. In this case, what happened? The compromise was arrived between the parties when the matter went to Supreme Court. At that stage, they compromised. And the Supreme Court.
Yes.
Lordship, I will not read the entire one. Last para 15 month.
15.
Yes. Here also, that he went to High Court, appeal, everything. In the instant case, the incident took place before more than 15 years. The parties are residing in one and same village, and they are also relatives. Appellant was about 20 years of age at the time of commission of crime. Was his first offense. After conviction, the petitioner was taken into custody. During the pendency of appeal before the High Court, he was enlarged on bail, but after the decision of High Court, he again surrendered and is in jail at present. Though he had applied for bail, the prayer was not granted and he was not released on bail. Considering the totality of facts and circumstances and opinion, ends of justice would be met if the sentence of imprisonment awarded to appellant accused is reduced to a period already undergone. So what I'm submitting here is one of the second leg of our argument is that if lordship doesn't quash the conviction under 482 CRPC, can reduce the sentence to the imprisonment or the custody he is already underwent during the trial. He was in custody for 97 days. It can be reduced to that. He has all the custody he has already.
He is still on bail.
He is bail on bail. Because the appellate court granted bail. Therefore, your lordship is aware our tribal society is such a small place. We all somehow or other.
Supreme Court has the power under 142.
No,
High Court doesn't have.
No, it says the inherent jurisdiction. That's what the Honorable Supreme Court in that says, the High Court was the wrong when it said it cannot quash, wrong application of law. High Court has the power. Inherent, definitely inherent 482 and 226 months. Almost in 226 also many people file for quashing of FIR. It's extraordinary power, inherent jurisdiction and 226.
Yes.
That's all,
Come to the facts then.
What happened in this case, the FIR was lodged by this complainant, saying that there was a theft in her house.
Petitioner number 2 is the informant.
Yes, Page 15A is the type copy of the FIR. Petitioner 2 is the complainant. So the complaint that they are neighbors,
Yeah.
And later on, it was he said, due to influence of alcohol and all that, he did that one. However, on the basis of this one, during the trial, everything, the property was returned to the owner, petitioner number 2.
So it's recovered. Recovered during the investigation.
Yes, no, returned from the house. Yes.
It was recovered or
some recovered, some the parents brought. The accused parents.
Paid.
Yes, materials.
Okay. Okay, then
Then page 36 is the settlement. Man. Yes. This is 24 years only, man. Very young.
24 years.
Yes. There's a saying, Malov,
What is the judgment?
the judgment is, Malov, it starts from
No, this judgment.
Malov.
2017, Punjab and Haryana.
Yes.
This is para 716, 7.
Malov, it starts from para 7. Man. To para, that one. That's para 7 on. In the entire.
Then if this petition is allowed, your petition is allowed, what would be, this will automatically goes. The appeal will. This is 2000 Supreme Court,
Malov,
2022. 14 SCC.
this is 2022 14 SCC 531 equivalent citation.
Sometimes it doesn't, it's not correct citation. They don't give the correct citation. Para,
Here,
Yeah.
Malov, para 13. Man.
only 13,
Yes. 13 and 15 man.
15
Yes. 13 and 15.
here.
Here, Malov, no, 2008 15 SCC.
Six, 7.
Yes.
Para,
Para, Malov, the 15 last para.
.380 is an offense against the public,
Malov,
the society.
it's not
It is a private,
just Malov, it
can it be said that it's a private dispute?
yes, Malov, it's against a private person only. So they have arrived at a compromise.
Is it not an offense against the society?
No, Malov. Same case, Malov.
Yes, madam.
Lordship, I have this judgment also. The Raghuveer Singh versus another versus State of Punjab, Lordship. Reported 27 September to 22, Lordship.
It's also the state of Punjab and Haryana.
Lordship.
Same judgment.
No, Lordship, this is under Raghuveer Singh versus another versus State of Punjab, Lordship.
What
Here,
did it say?
Lordship, the petitioner who stand convicted in the trial for the FIR caption above have come up before the court under section 482 for questioning the judgment of conviction, sentence, charges, and the FIR based on compromise with the victims, Lordship. The Lordship here, this
With the relevant paragraph?
the paragraph is Lordship, 5 Lordship. On the pair of these parties in the present petition, Lordship, the court has permitted the parties to appear before the concerned court to record their statements. As per the concerned court report, the victim without any threat considered the crossing of the FIR and consequent proceedings. As per my understanding, Lordship, they have, although they have the prayer was lordship accepted, but they have to appear before the concerned court, lordship. The analysis and the reasonings, lordship, thereby, despite the severe opposition of the State Council to this compromise, the following aspect would be relevant to conclude this petition. The accused and the private respondent have amicably settled the matter between them in terms of the compromise deed and the statement recorded before the concerned court. A presumed document revealed that the settlement has not been secured through coercion, threat, social boycott, bribes, or other dubious means. The victim has willingly consented to the nullification of the criminal proceeding. There is no objection from a private respondent in case present FIR and subsequent proceedings are quashed. In the given fact, the occurrence does not affect public peace or tranquility, moral turpitude, and harm to society laws. And the rejection of compromise may also let ill with the pendency of trial, affect career and happiness. NG lordship, there is nothing on the record to prima facie consider the accused as an
What is the
unscrupulous
relevance
lordship.
of this you would like to rely?
Lordship, here, lordship, they have quashed the lordship, the conviction, lordship. This is lordship, the conviction, the quashing is allowed, lordship, in this judgment also, but the certain terms and conditions is imposed, lordship.
Yes.
They have lordship in the lordship paragraph 23 lordship. In Gampa government of state of Andhra Pradesh lordship, the trial court convicted the sole appellant undergone section 326 of the IPC. The sentence undergo rigorous imprisonment 3 years lordship. Then they have appeal lordship. On appeal, they have been prepared the session court confirmed the conviction sentence. When the matter was taken to the High Court, the revision conviction sentence under section has been set aside. Appellant has been convicted under section 24 IPC and sentenced to undergo rigorous imprisonment for 1 year. Before this court, a joint petition compromise has been filed, wherein it has been stated the parties have settled the dispute. As such, they be permitted to compound the offense. In our
What do you say?
lordship, as per my understanding, lordship,
Even if the appeal is pending,
lordship,
the jurisdiction can be accessed under 482. That is there. For non-merit,
lordship, here, lordship, the appeal is lordship pending, lordship, in the appellate court, lordship. In the meantime, they have exercised this 482. And lordship, as per my understanding, when the appeal is pending, the court is the case matter is reopened, and the honorable court has the jurisdiction to interfere this
even if the appeal is pending.
lordship, because lordship, this is case is reopened now, lordship.
Hmm?
Reopened now, lordship. This matter is
What is reopened?
lordship, because lordship, when convicted, lordship, it was
The
closed, lordship.
continuation of the criminal proceedings.
Lordship,
Until it is it attains finality. Appeal
Lord-
is as a part of criminal proceedings.
lordship. This way, lordship. Is it what's convicted, lordship? Its order was passed, lordship. And again, they have to the appellant court, Lordship, for the appeal,
It's
Lordship.
okay, I've understood. What is
Okay.
the, on merit, can this be,
Lordship, as per this judgment, Lordship, they have already invoked the appellant before the appellant court, Lordship. They have confirmed the Lordship conviction, Lordship. After after that only they have come for the settlement and they apprised the court, Lordship, for settlement. And the court has also, Lordship, when the settlement done, they have to see whether the parties have appeared before the court, Lordship. Maybe they have called for the Lordship in person. They have called before the court. Otherwise, Lordship, let the appeal matter maybe, Lordship, heard first, Lordship. And they can, there also they can go for this settlement. They
have you
can apply
placed
this, Lordship.
this settlement, this compromise before the
Appellant court,
appellate
Lordship.
No,
In some, ca-
after conviction,
huh,
yes.
what did he say?
Malad?
What the court says?
No, Malad, the notice has been issued to the other party in that appellate court.
No, so they have called for
No,
the,
have you placed this compromise settlement agreement, settlement?
It would be heard, Malad. Next date was fixed, Malad. You have to confirm.
Then
That we will place it with
let us do one thing.
No,
I
sir.
thought I'll dispose of the matter
Yes.
by looking at all this thing. You place all this thing, the compromise, that will be heard before the appellate court.
Yes.
Let then in that case, you may ask for recording the statements also of the parties, because respondent will be appearing.
Yes.
And then if the court doesn't accept it, we may look into all those statements, right? So we'll fix this matter for some other date. When is the next date before the appellate
I
court?
have to check it out, Malad. Bombay
Because going through all the judgment of this, the Punjab and Haryana High Court, certain modalities has been worked out. It's not that you just can work, I mean, it has to, you have to look into the merit also.
Yes.
It's not just because it is compromised. Now, I'm clear that even if the appeal is pending, can be considered.
Yes.
Depends on the facts and circumstances of each
Yes.
case.
Yes.
So we'll adjourn it and we'll list it for some other day and you get yourself recorded and whatever is there before the appellate court. Right?
Yes.
Heard Mr. Pita, learned counsel for the petitioner. And also heard Ms. M.S. Elhage, learned additional people. Come on. Please stop. It is stated at the appeal filed by the appellant against the conviction and sentence, na?
Yes.
That is which?
Dated, Malad.
14/12/2023,
Yes.
passed by the Chief Judicial Magistrate Sepa. Pending before the learned session judge Bomdila is scheduled to be listed on
Malad, date I have to check. Malad. Criminal appeal number 1 of 2024.
Criminal Appeal number 1 of 2022. 24, na?
Yes.
24 is scheduled to be listed and heard before the appellate court. List of next paragraph. Considering that the present petition has been filed for quashing of the conviction and sentence on the basis of compromise, while the criminal appeal number 01 of 2024 is pending before the learned session judge, Bomdila, West Camden District. Let the matters be listed after. Let the matters be listed after 4 weeks.
Yes.
4 weeks, please stop. It is the parties are at liberty to record their statement before the learned session judge. With regard to the settlement, with regard to the settlement agreement, what do we call it?
Settlement.
Settlement deed
Yes.
dated 27/02/2024. Very recently, 2024. In the event, the criminal appeal could not be, is not considered and disposed of is not disposed of.
Yes.
Or is it they're hearing it for IA or something like that? No,
No, the IA already, malab, he has been granted bail.
granted.
IA
Is not disposed of.
Yes.
If the courts allows your appeal, it's nothing surprise.
Yes.
But if it doesn't,
Yes.
you get your statement recorded, both victim and the informant,
Yes.
so that we can consider the next day
Obliged.
in this.
Okay.
This recording.
All right.
Number 25.
What is this?
Lordship. Your Lordship, the learned counsel for the matter is went for some urgency.
On the prayer of MS, your name?
N only,
Learned Counsel on behalf of,
Titaba.
appearing on behalf of MS, Mr. T. Thaba, Learned Counsel for the applicant.
Yes, Lord, your Lordship.
List
Lordship,
this matter after 4 weeks.
sir, matter may be fixed for tomorrow.
Tomorrow not possible. You have to see the convenience of the court also, not always your convenience. After a week.
After. Deeply obliged.